client had a will. She even had a trust. All her papers were neatly organized and readily available to her family. But when she died, her surviving family ended up in conflict, in court, and dealing with delays and expenses, all of which could have been, and in fact should have been, avoided. What went wrong, and how can you make sure this doesn't happen to your family? So here's a very common scenario. The client, we'll call her Susan, was a widow with 4 adult children. Susan's goals were straightforward. She wanted her 4 children to receive equal shares of her assets. She wanted things to be simple for her kids. She wanted to avoid probate, and she just wanted everything to be handled smoothly. Susan took many of the steps necessary to make sure her intentions worked out as planned. She even created a revocable living trust. She had a will, powers of attorney, everything. Now, this is a great start to an effective estate plan. However, by stopping there, her plan did not operate as Susan wished. So what went wrong? Well, let's start with what Susan did right, because of course these steps are important. She created all the necessary documents, including a trust as a means to avoid probate. She named her children as beneficiaries in the trust. She chose a trustee, and she signed all the right documents and had everything well organized. So far, so good. She's done things correctly. However, estate planning isn't just about having documents. Rather, it's about how those estate planning documents coordinate with your other documents and how everything works together. So here's where the plan failed. The first problem in Susan's case deals with the retitling of assets. Her trust was not ever funded. That is, while the trust was created, none of her assets were tied to or properly connected to her trust. For example, Susan still owned her home in her own name. She had never transferred the title of her house to her trust. In Minnesota, individual ownership of real estate leads us straight into the probate court. Susan had a savings account and several CDs at her local bank. These accounts were all owned by Susan individually. Because of this individual ownership, these accounts required the probate court's involvement to transfer them into the trust. Because the retitling of her assets did not happen, the one thing Susan did not want, probate, became necessary. A second problem related to asset titling. Susan also had a checking account in which she kept a pretty significant balance. Susan had named one of her children, Kelsey, as a joint owner of this account. Susan's intention was convenience, that is, so her daughter could write checks from that account if necessary. Well, with the joint ownership of that account, her daughter Kelsey was entitled to receive the entire balance after Susan's death, with no obligation to split the funds with her siblings. A third problem was outdated beneficiary designations. Susan had a long-standing life insurance policy dating from her pre-marriage days, which named her sister as the beneficiary. So, despite the provisions in her trust and regardless of her intent to divide her assets between her children, the proceeds from that life insurance policy were paid to her sister. This, of course, was completely unintended. Beneficiary designations on life insurance policies, annuity contracts, and, importantly, retirement accounts all override your will and trust. Next, there was no plan for personal property. And here's where things became emotionally charged and difficult. Generally, wills and trust agreements, these documents do not specify in detail how personal items such as jewelry, furniture, family heirlooms are to be distributed. Instead, the will or the trust will authorize a separate writing where you can set forth who is to receive important family items. Like so many people, Susan did not take the time to complete this separate writing. With no clear plan, her kids started asking, "Would Mom have wanted me to have this? No, she promised this to me. And suddenly, conflict. A final problem was not talking with the children about her estate plan, particularly her choice of trustee. Susan had named one of her children to serve as the sole trustee. There are various options for who to serve as trustee or even co-trustees, and naming an adult child is an absolutely fine choice. However, when the time came for the one child to administer the trust, the other children felt left out and, in fact, somewhat suspicious. So the mistake was not discussing the reasons supporting her choice of trustee to all the children. I understand that this conversation could, in some circumstances, be difficult. However, assuming you have solid, valid reasons for choosing someone to serve as your trustee, we can find a way to communicate that to the other interested people. And during your lifetime, there will be opportunities to clear the air and talk things through. These conversations can prevent a lot of future resentment. Now, none of these problems required a complicated fix. They required making sure assets were properly titled, reviewing beneficiary designations regularly, leaving clear instructions for personal property, and communicating your decisions with your family. The hardest part about this story is that Susan undoubtedly put in a lot of time and she did so many things right. However, because of the mistakes made, the administration of her estate did not go as she intended, and her family was left to deal with the consequences. With the guidance of a thorough estate planning attorney, these mistakes should have been avoided. So, if you already have your estate plan in place, the question is not, do I have all the right documents? Rather, the question is, have I taken all the steps to make sure my plan will operate as I intend? Thank you so much for watching.